Hi, I'm Rick Harmon. If you're a real estate agent or broker dealing with inherited property anywhere in California, there are a few things you need to know, and I want to provide you a few insights in the form of a few videos you can use. No legal advice, nothing really technical, but some basic things you can apply in making your life easier for you and your seller. Just like people are not all the same, trusts are not all the same. You need to be aware of this. Someone says they have a property in their trust, well, that's well and fine, but you need to see the trust, or at least the declaration page, to make sure that your seller has the ability to sell. No, this is not a probate. Typically, unless a trust is in litigation, or if a trust comes out of a probate estate where a will is created that creates a trust within it, most of the time, a trust does not require probate, but a certain number of people do have things to say about the sale of a property. So you need to make sure that the trust does not say that this property is supposed to go to Jimmy down the street or to the American Red Cross. So you make sure that you're in this case, your successor trustee has the ability to sell. There's usually four things we look for in a trust. Number one, we want to see a copy of the title page. And this is for the title insurance company. So with the title page, get the full vesting as it relates to is it a recorded document. The second thing we want to make sure is look at the signature page. Okay, now the signature page of a trust does not have to be notarized, although it usually is. Now the next thing is the trust does need to be funded. And what that means is that the property has been transferred out of the name of the decedent by way of a deed, typically a trust transfer deed or a quitclaim deed, occasionally a grant deed, they'll do it this way, into the name of the trust, and it has to have the name of a trustee, usually the settlor. That's the person who's created that trust, but now that person is likely to be deceased. And so the title company is also going to want a copy of a death certificate or other corresponding documents to show how the successor trustee came into power. Lastly, we want to look at those powers in that page in the trust document that's sufficient to show that that individual who is successor trustee does in fact have capacity, powers, and authority to sell the property. They'll typically do a trust certificate or certification of trust that allows that to be possible. Sometimes it's not obvious how somebody came into the power of being successor trustee. So for example, title companies looking at it, they're getting into the middle of the story and they want to know, okay, how come the milkman is now the successor trustee? That seems a little odd. So what we want to be able to do is be able to show a chain of evidence, or basically connect the dots and make it easy for the title company personnel to be able to see that your client who is selling this property that's currently held in a trust, and to be able to do that efficiently. Now, here's a common scenario. Common scenario is that somebody has lost the trust. Well, what do? You're going to go back to probate court. If they don't even have a copy of it, that's going to be a big issue. You're probably going to end up having to do a probate. I'm not an attorney, as you know, but I have seen many hundreds of these cases. Sometimes there is a trust and the decedent has taken the property out of the trust that they put so much time to put together, and to get a new loan like a reverse mortgage or some other kind of a lending transaction, and take the property out of the trust and they never put it back in, meaning they never transfer title back into the trust because the escrow or the loan broker or whoever it was, or the credit union or such, or their bank, never took the time to do this, or occasionally some fast-moving attorney or paralegal or legal doc service failed to complete this. And so you'll discover that the title of the trust is not actually in the trust. So then it's going to be necessary for an attorney to go to court and do what's called a quiet title action, and they make reference to a Hegsted matter. You don't have to spell that, but basically there are often ways to solve these things. One of the most common things that we find, though, is where the trust itself has been lost. And that is going to be something that you're not going to fix. If there is no trust, there is no copy of the trust, and it was never done or it was never signed, that's basically the same as there is no trust. So you're going to be dealing with probate, or at least this title issue, one way or the other. So I strongly suggest you think through that and you line up this paperwork in the front end and check this off and say, hey, can this party who wants to sell the property, do they have that capacity, powers, and authority? Do they have the paperwork? Do they have the supporting paperwork? Can you see how that came into being so that they can affect the transaction that you want to sell? And if it's compounded by other problems, by a partial interest of a property, or a trust that says, well, somebody is supposed to receive this property, or somebody has the power to, or is intended to keep the property in their name as like a life estate. You need to know that before you set yourself up for a major lawsuit. That's a biggie. Hey, this is Rick Harmon from closeprobate.com. Hope you got something useful out of this video. If you want more information, subscribe to my YouTube channel. And while you're at it, subscribe to my weekly blog, Rick's Rants, at rickharmon.com. Look forward to seeing you on the other side.